Case number 116250, State of Kansas v. Yesenia Jimenez.
Chief Justice, and may it please the Court. Ms. Jimenez appears through counsel Casper Shire, Assistant Public Defender, North Central Regional Public Defender's Office. Your Honor, could I please reserve 3 minutes for rebuttal?
3 minutes is granted.
Thank you, Your Honor. This case comes out of an I-70 traffic stop conducted by Officer Nicholas Blake on January 11th, 2016 in Geary County, Kansas. Officer Blake stopped a black Ford Mustang for following the vehicle in front of it too closely. He made contact with the vehicle occupants, he collected licenses and vehicle rental information, and he asked Ms. Jimenez to accompany him back to his patrol car. She complied. Before Officer Blake contacted dispatch to request a warrants check on Ms. Jimenez, and before he began writing a traffic citation, he began questioning Ms. Jimenez about her travel plans, including where she had been, where she was going, the purpose of her trip, where she had slept, and who she had spent time with. Because Ms. Jimenez spoke very little English, this questioning was conducted through a cell phone translation app called Google Translate. About 4 minutes passed from the time Ms. Jimenez exited her vehicle to the time Officer Blake contacted dispatch to request the warrants check. When Officer Blake requested the warrants check on Ms. Jimenez, he also requested a warrants check on the passenger, Mr. Pablo Payeras, and in addition to that, requested a criminal history check, or III, on both Ms. Jimenez and the passenger, Mr. Payeras. After that criminal history request, Officer Blake ran his drug dog around the vehicle. The dog alerted. A subsequent search of the vehicle revealed numerous bundles of U.S. currency, later alleged to be the proceeds of a drug transaction. Ms. Jimenez filed a motion to suppress, which was granted by District Court Judge Maritza Segarra, and the state filed an interlocutory appeal challenging the district court's finding that the traffic stop was illegally extended by the travel plan questioning, but not challenging the district court's finding that the traffic stop was illegally extended by the criminal history request. The Court of Appeals reversed, and this court granted Ms. Jimenez a petition for review, bringing us here today. Your Honors, the district court judge in this case made a factual finding that Officer Blake was on a fishing expedition when he began questioning Ms. Jimenez about her travel plans. The district court made a further factual finding that Officer Blake was on a fishing expedition when he requested her criminal history and the criminal history of the passenger of the vehicle, Mr. Pablo Payeras.
Let me ask you about that one, since you brought it up. I don't think there's any question that the Rodriguez case lets officers deal with both outstanding warrant checks. You'd agree with that?
Yes, Your Honor.
And then there's this sort of amorphous concept of officer safety that I think comes up through Rodriguez, and you agree with that?
I agree with that, Your Honor.
So the inquiry, so we do a warrants check, the inquiry into criminal history, do you think that falls outside one of those two permissible subject matters?
I do, Your Honor, and I feel that's particularly the case when the district court makes a factual finding on the record, as she did here, that the questioning and the criminal history check in this case was investigatory in nature.
Let me ask you about that then. Isn't that getting into the district court's legal conclusions as opposed to the factual findings? I mean, there's no dispute there was an inquiry into the criminal history. So, I mean, that part's good. The question is, what do you make of that under the law? And it seems to me that I don't have to, as an appellate judge, I don't have to accept that conclusion from the district court because it's a legal conclusion and I'm supposed to do that part de novo. Do you agree with that?
I don't agree, Your Honor. I think that the purpose of a criminal history check can be a factual finding that is appropriately made by the district court. And I believe that the district court's factual finding that this particular criminal history check was investigatory in nature and not related to the traffic stop in any way, either to writing the ticket or to any possible officer safety concerns, is well supported by the record evidence.
And so what would be the record that would support the notion that the criminal history inquiry was not related either to a check for warrants or a check for officer safety?
Well, Your Honor, first of all, there's a difference between a warrant check and a criminal history check. Those are two separate requests which the officer needs to make separately. And he did make those requests separately. So this is something in addition to simply a warrant check. Second of all, there was nothing presented in the record which would suggest that Officer Blake had any reason to be concerned for his safety during this stop. He invited Ms. Jimenez to exit her vehicle and to enter his vehicle. He had an opportunity to pat her down for weapons or any other things that may have affected his safety if he felt like that was necessary. I don't believe that he did that. There was simply nothing in the record that would have supported a finding that this criminal history check was related to officer safety as opposed to being an investigation into the possibility of other crimes.
When he took defendant to the patrol car, was the passenger left in their vehicle?
Yes, Your Honor. I'd like to talk to this court about the importance of Rodriguez, because Rodriguez is an extremely important case which has changed the landscape of traffic citation stops. Rodriguez does build on the cases that came before it, such as Caballes and Johnson, in saying that when investigation measurably extends a traffic stop without reasonable suspicion of additional criminal activity, it renders that traffic stop unconstitutional. But Rodriguez goes farther in three important ways. First, Rodriguez defines what is incident to a traffic stop much better than its predecessor cases. Rodriguez says that in order for an officer's actions to be incident to a traffic stop, they must be reasonably related to traffic enforcement goals of ensuring that vehicles are operated safely and responsibly. Second, Rodriguez clarifies that even de minimis extensions will render a stop unconstitutionally extended if those de minimis extensions are for the purpose of investigation, as opposed to, for example, officers' safety concerns. Third, Rodriguez expressly states that the timing of the measurable investigatory detention is not important. It does not matter whether that measurable extension occurs at the beginning of a stop, in the middle of a stop, or at the end of a completed traffic stop. Once we have a measurable extension, which is for the purpose of investigation, the stop is illegally extended.
What's measurable? I mean, what's de minimis and measurable time-wise? 5 seconds, 30 seconds, 2 minutes? What do we?
As I read Rodriguez, I believe 1 second is a measurable extension, Your Honor.
So it's quite literal. And any extension that can be gleaned to be investigatory would be not permissible.
I believe that is exactly what Rodriguez says, Your Honor.
But I don't think we can go there. And the reason for that is because officers can ask any question they want to, don't you agree, as long as they're within the mission. In other words, if the officer gets on the radio and says, I want to do a warrant check on my driver here, and that's going to take a couple of minutes, and while they're waiting to hear back from the dispatcher, he can ask any question he wants to, can't he?
Yes, Your Honor.
And so that part's fine. The nuance here is when the question is, and I think you kind of have that in this case, because the questioning about travel plans, whatever that label means, occurs before he radios in for information. So you've definitely got some extension here going on. But we can't just say any one question is going to do it, because you're allowed as much freedom as you want to ask, as long as you're not extending the stop. And that's the hard part of this, don't you? Articulating it that way.
I agree with you, Your Honor, and I think this is exactly where the district court comes in. I think this is exactly the role of the district court judge. The district court judge is perfectly capable of looking at the types of questions that are being asked, the amount of time that is being spent asking these questions, other factors, other things that may be going on in the traffic stop that will allow the district court to make a factual conclusion about whether this is incident to the traffic stop in some way, or whether this is investigation into other crimes that the officer has some kind of a hunch may be being committed.
And that gets me back to my problem, because we know what the questions are here. I mean, we got a tape, and so there's no dispute about the sequencing of the questions. There's no dispute about what questions were there. And so it seems to me like the role of the district court is more limited when we have undisputed facts. And that's where I'm also trying to draw a line here about how much I have to accept from the district court on these conclusions versus what are, legal determinations. Here's an example. The officer says, well, the driver and passenger were nervous. Well, if the district court says, I've heard the facts, I've heard the evidence, and no, they weren't nervous, I think maybe from the appellate side, that fact, you check that off, give it to the district court. But when you talk about whether the question was incident to one of the missions, that seems to me to be a legal conclusion. Am I off base on that?
Your Honor, I still believe it to be a factual determination that the district court can make based on the evidence that's presented.
The district court still has the witnesses in front of them at the hearing, doesn't it?
That's correct, Your Honor. And I believe the district court is in the best position to weigh witness credibility, among other things, and to make that factual determination.
Let me ask you about the bundle of cash, and the state doesn't make an issue of that. I'm not sure you get hung with this one, but I want to ask about it generally. The officer, while your client and the passenger are getting the vehicle registration, open the glove box, and there's a bundle of money with a rubber band around it. Just the officer seeing that, doesn't that trigger permissible questions about where you're headed, what are you doing, things that, doesn't that give a suspicion of criminal activity?
I do not believe it does, Your Honor, and the district court clearly made a factual finding that there was no reasonable suspicion in this case. I think it's perfectly normal for two people on a long cross-country trip to have a substantial amount of cash on their persons. And clearly the district court agreed with that because they found that there was no reasonable suspicion to ask the types of travel plan questioning that were being asked, Your Honor.
Well, in your case, the officer did too. He said he didn't suspicion anything just
based on the side of the money.
I understand that, but it just seems like if the officer hadn't given that away, that might be something to talk about in terms of reasonable suspicion and whether additional questions are going to be permitted from that. But you don't think so?
I don't think so, Your Honor, and it wasn't raised before the appellate court, so I don't think it's an issue before this court either.
Typically, we've all seen this enough to know that during the traffic stop, the exchange of the license, there could be the multitasking by the officer. During that time, he's asking many of these questions, and so that they do not delay the traffic stop. Here, there was that extenuating circumstance of having to use the Google Translate, and that really is probably what caused the extension. It seems that perhaps if there hadn't been that English language barrier, that it might have all happened without an extension. Does that come into play at all in the consideration?
I don't believe it does, Your Honor, because we still have a factual finding that the questioning was investigatory in nature and not related to the original traffic stop.
So it wouldn't, what you're saying, it wouldn't matter if there wasn't a language barrier. The fact that he's asking questions to investigate possible drug trafficking wasn't permitted, whether it was with iTranslate or in Spanish or in English. That's your position, right?
Once those questions extend the stop, Your Honor.
Right,
Yes.
right.
Yes.
Not, and there's no question here that they weren't while he was waiting for dispatch to return the information. It was before he submitted the information to dispatch.
That's correct, Your Honor.
And I've got a question with that. It's set out at 5 minutes and 34 seconds between the vehicle stop and when Officer Black called dispatch. How is that measured? Did we have a body cam or a vehicle cam? And so we have something that actually measured the time.
Yes, Your Honor. There was a dash cam video from the officer's vehicle, which was facing forward and which basically captured the entire interaction, including the conversations at the vehicle, and also captured all the conversations that occurred inside the vehicle after Ms. Jimenez came back. That video was entered into evidence at the suppression hearing, and it is in the record on appeal. And so that video does give us an accurate count on how much time passed between various points in the stop.
And if we find that those questions, while they were in there, in the car, while the time is being shown on the vehicle cam, were unrelated and not within the scope of the traffic stop, not permitted by the reasonable suspicion for the traffic stop, we have a measurement. We have, if we're going to be literal, we have a measurable extension because it's measured with the state's own evidence.
I agree, Your Honor.
But your argument is that we don't really need to care about the time, and that gets back to my point about sequencing. It's the sequence of the questions that really is this case presents. It doesn't matter. The Google Translate doesn't matter because if it had been proper questions, then you can use whatever reasonably you need to do in order to communicate back and forth. The problem here is the officer put that line of questioning ahead of the permissible missions of the traffic stop, right? So it doesn't matter whether it took 5 minutes or 30.
I think once it is questioning that is investigatory and it's, again, put ahead of the incidents to the traffic stop, which need to be completed as part of the traffic stop, then yes, Your Honor, I agree. It offends the Constitution at that point.
Let me ask you one other question. The rental agreement. It seems to me, and I appreciate the state hasn't made this argument, but I'm curious about it. It seems to me that we know an officer is allowed to talk about registration, ownership of the vehicle. That's one of the missions of the traffic stop. And the officer gets a rental agreement. It seems like that automatically is going to allow some additional, that's going to trigger some additional appropriate questions as to ownership. Would you agree with that?
I don't agree, Your Honor. I think a rental agreement can show, and particularly in a case like this one where the rental agreement showed that the passenger of the vehicle was in fact the one that rented it. So we're not dealing with a case where somebody else rented the vehicle and two other people are inside it. We're dealing with a case where the person who rented the vehicle is sitting in it. He's given the officer his license. Once the evidence that the officer has collected shows that the person who rented the vehicle is in the vehicle, he's authorized to have control of that vehicle at least for the period of the rental, I think that satisfies all that the officer needs to do to complete the traffic stop at that point.
Just being handed the rental agreement doesn't permit additional questions beyond. It just depends on the circumstances of who's in the vehicle.
Correct, Your Honor.
Okay.
But the officer can ask any question that the officer wants to while he or she is reading the rental agreement.
So long as they are not extending the stop, then yes, I would agree. The officer can ask any question they want to.
Any further questions? Counsel, we've taken a lot of your time with our questions. Do you need about 30 seconds to wrap up, or do you just want to wait until rebuttal?
I would like 30 seconds, Your Honor. Thank you. I would ask the court to reverse the Court of Appeals and to affirm the district court, not only because the district court was correct in its ruling that this stop was illegally extended by travel plan questionings, but also because the district court was correct in its ruling that the stop was illegally extended by the criminal history check, an issue that was not raised on appeal by the state, and therefore I don't believe is properly before this court. Thank you, Your Honor.
Thank you.
May it please the court, Tony Cruz on behalf of the state of Kansas. United States versus Rodriguez, since it came out, the defense bar has basically claimed that it's a watershed rule now. That is the grand poobah of all cases. And they cite it, and in my 20 years of being a prosecutor, it's probably the most miscited, misquoted case I've ever seen come out of the U.S. Supreme Court. And here's why I say that. There are paragraphs that were taken out of Rodriguez that are quotes out of United States versus Sharp. That's a 1983 case. And that's where you get the language about the mission and what's permissible during a traffic stop. A lot of cases have come out of the 10th Circuit and this court since 1983 that specifically deal with travel plans. And if you look at the facts of Rodriguez and not just quote certain quotes here and there, Rodriguez has a case, that starts out as a traffic stop, occurs around midnight. There's two occupants. Deputy goes up to the car, talks to the two occupants. He approaches from the passenger side, gets the information of the driver to include his driver's license, goes back to his vehicle, runs what's referred to as a computer check. And of course, we don't know what exactly ran, if it was just a driver's license check, if it was a warrants check, if it was a criminal history check, don't know. However, after some time, same deputy goes back up to the vehicle, returns the driver's license, talks to the passenger about travel plan questions, gets his information, goes back to his patrol vehicle, runs that person's name through their system. Approximately 25 to 26 minutes after the initial traffic stop, he reapproaches for a third time and issues the warning citation. And that's where we hit in the question of him asking permission to search, and it's denied, and he detains him. Rodriguez only deals with, does an officer have to have reasonable suspicion after a traffic stop to run a drug canine? That was the only issue in Rodriguez. And the U.S. Supreme Court said that if you're going to detain a vehicle and its occupants after a traffic stop is over, you have to have reasonable suspicion under those circumstances, because they denied consent. There was no consensual encounter.
Well, Mr. Cruz, we have plenty of precedent, both U.S. Supreme Court and our court, that says that a Terry stop, which is what we're dealing with, investigatory detention, is only permitted to last so long as to take care of that which gave rise to reasonable suspicion, right?
Yes, sir.
And in a traffic stop for a traffic infraction, pretextual or not, that scope is to take care of the traffic stop. And I can recall we have some cases that specifically say the officer can only detain the person long enough that it would ordinarily take to write a ticket check wants and warrants, and the person then has to be on their way. And so that's not a new concept, is it?
It's not a new concept. The manner in which Rodriguez is trying to be applied here is a new concept. And that is that basically, Judge, the defense doesn't want officers to ask any questions during a traffic stop. Because why? Because that they're afraid of what the answers might be. And so therefore...
Well, why do they get to investigate drug trafficking for following too closely? Why, under our law that says a Terry stop is officers only permitted to investigate that which gave reasonable suspicion to allow the warrantless seizure?
The only questions here that were asked were travel plan questions.
Well,
this
what do travel plans have to do with following too closely?
Because
if I leave the Ramada Inn and go on I-70 to Wanamaker, can I follow closer than if I'm going to Denver?
No.
So what difference does it make what your travel plans are if the reason for the stop was that he was following the car in front too closely?
Because this court in State versus Morlock said that travel plan questions are part of the traffic stop. And our appellate courts have found that travel plan questions are permissible because they're part of the traffic stop. For example, if somebody's driving too fast, the officer can ask, where are you coming from? Where are you going? Why are you driving so fast? If there's an emergency, that would advise the officer why that they're driving 90 as opposed to 70. If it turns out that that they advise because I'm traveling cross country, well, that may explain why that they were weaving or why that they're following too closely. And our appellate courts have held that travel plan questions fall within the ordinary scope of a traffic stop. This isn't the officers going off and asking questions about criminal history or things of that nature. These are travel plan questions.
Counsel, I think I read Rodriguez completely differently than you are, and so you're going to have to move me off of this. But let me tell you where I read this case, and it tells me what the appropriate subject matters that can be inquired by an officer as a part of a normal traffic stop. I mean, they itemize it. Driver's license, warrant check, automobile registration, vehicle insurance, and then a sort of a broader category of officer safety. Travel plans isn't listed in Rodriguez.
Because Rodriguez didn't address travel plan questions.
It addressed, but it said these are the appropriate inquiries for a traffic stop.
It said that
so it doesn't matter. I mean, when they're telling us these are the things you can ask about, that seems to be pretty authoritative from the U.S. Supreme Court. And when the dissent in Rodriguez objects to those things, it tells me these guys discussed it and came up with some rules. So how do I ignore, you want me to ignore Rodriguez, and I don't see how I can. And that's my problem.
Because, again, the sole issue in Rodriguez was whether or not an officer needs reasonable suspicion after a traffic stop to detain somebody. If the issue in Rodriguez was, is it permissible during a traffic stop to ask about travel plan questions? Then how is it that the court in Rodriguez didn't say, because the fact the officer asked both the passenger and the driver about travel plan questions, he lengthened the traffic stop so it was unlawful, period. So at that point, it doesn't matter whether or not he had reasonable suspicion afterwards, because he was already unlawfully detaining the two occupants. Again, the list that's included in Rodriguez, that's an inclusive list. It's not an exclusive list. Because the other thing is, they also talk about, in certain circumstances, officers are allowed to ask about criminal history. And if they weren't allowed to do that, then why even bother having this list? And again, if that was the real issue in Rodriguez, the U.S. Supreme Court never touched it. Why? Because it wasn't the issue.
Is it your position that that list that has been referenced is just dicta in Rodriguez?
No, that is that list is not an exclusive list, meaning these are the only things you're allowed to ask. It tells officers what they're permitted to ask, but as we know, certain things, travel planning questions, are permitted. And appellate courts since Rodriguez have held travel planning questions to be outside of Rodriguez, and have said travel planning questions even after Rodriguez are permissible during a traffic stop because they're part of a traffic stop.
You mentioned a couple of examples, the speeding when you're going to an emergency,
Yes.
or the weaving when you're going cross country. Those are distinct from following too closely, aren't they? We've already established that travel plans are irrelevant to following too close. Just a minute, sir, I'm not done.
No,
Travel,
because
excuse me, sir, I'm not quite finished. We've already established that following too closely is not one of the traffic offenses where travel plans would be relevant, right? You said that in response to my colleague's question.
I think it would be relevant, regardless of the traffic infraction. Because again, if they were traveling long distance and they weren't paying attention, i.e. they were starting to fall asleep and they started to creep up on somebody, that would become relevant because again, the officer can say, hey, slow down, stay awake, pull off the side of the road. So it is relevant.
So the answer you gave earlier was mistaken.
If I misspoke, I apologize. I may not have heard the question properly, but I think for virtually
all traffic stops, regardless of the violation, travel plans are relevant.
they can be.
Okay, so it's not all, in some circumstances. I'm just trying to figure out what the boundaries are here, and I think what you're saying is it depends.
It depends on the facts.
Okay.
For example, if you know what we're dealing with here happens to be an I-70 stop, so we assume that people are traveling long distances because they're on I-70. But it also depends on the time of day. It also depends on the weather. It also depends on the traffic flow.
And one of those facts is the type of violation for which the car's been pulled over, right?
Yes, ma'am.
Thanks.
So.
You said that there were some cases after Rodriguez that support your position. I've got your brief in front of you, and you don't cite any case before or after 2015, which is the date of Rodriguez.
And I apologize when and I'm still amazed that when you do a query search and you don't put in all the terms, that you get certain cases and then you change that query search by one word and all of a sudden things pop up. But there have been 3 cases that I know of out of the 10th Circuit, and I can provide to the court that those sites. One, as a matter of fact, is out of 10th Circuit just last year. And that is United States versus Cone, spelled C-O-N-E. It's 868 F 3rd 1150. There's also United States versus Pettit, P-E-T-T-I-T-T, at 785 F 3rd 1374. That came out in May of 2015. And there's also United States versus Moore, 795 F 3rd 1224, and that's out of the 10th Circuit, and that came out in July of 2015. There's a couple other cases that came out of the district court. I believe it's New Mexico, but I think that those 3 10th Circuit cases are sufficient to show that Rodriguez is limited to the facts in Rodriguez. Because again, if the question is, and because Rodriguez even cites the Johnson case out of Arizona, and if it were that officers were not allowed to ask any questions outside the scope of a traffic stop, then effectively Rodriguez would be overruling Johnson. And they don't do that. As a matter of fact, that they incorporate Johnson. And our appellate courts have also said that when you talk about measurably has been interpreted as to excessively extend the traffic stop. Because otherwise, Johnson has no bearing. Because if you ask one question, being, where did you come from? Kansas. That's 3 seconds. That's 3 seconds too long.
Well, let me get a couple of things out
Sure.
of the way here. You don't make an argument that the bundle of money permitted any additional questions as follow-up, correct?
Correct. And in these circumstances, based on the author's, testimony now.
Nor do you argue that the rental agreement triggered any additional need for questioning, correct?
Correct.
So, we have these travel plan questions that are sequenced prior to the officer phoning in or radioing in the request for the warrant information. Since you've said it depends on the circumstances whether you get to ask travel plans, which I take to be a different argument today than what you argued. I took to be that travel plans are always okay. So explain to me, under these circumstances, why this officer got to sequence travel plans ahead of radioing in for the warrant information. Because clearly the stop was extended by wanting to ask those questions, with or without Google Translate. I don't even care about that. It's just the inquiry extended this stop. What justified those questions under these facts?
These facts, I believe, are different because you had somebody that was following too closely. It was at night, and given those circumstances, I believe that the officer was permitted to ask questions about their travel
So
plan.
you've listed two things, following too closely and at night. Explain to me why the travel plan questions that this officer asked are okay when the stop occurs at night.
Because, again, for the violation, and this would be no different than if the officer had witnessed a violation, let's say, at 2 o'clock in the morning. Common experience suggests at 2 o'clock in the morning, if there's a traffic violation, there's a possibility that the person may be under the influence. So is the officer allowed to ask questions about alcohol? Yes. Does he have to smell it? No. But he's allowed to ask. And again, it's one question. In this particular case, we've got somebody who believes that the officer indicated that was, or he believed to be going cross country. But again, since our courts have held that travel plan questions are part of the traffic stop, are they permitted to ask travel plan questions? Yes. Do they have to? No. But are they permitted to do so? And I think our appellate courts have all said yes, that they're allowed to ask travel plan questions. Now, can those travel plan questions exceed what would be reasonable? You know, the officer asking 20 to 35 minutes of travel plan questions, that's probably going to be unlawful.
So it's in this scenario, it's the time of day that allowed the extension.
I think, and again, Judge, Judge Beyer, I may have gotten things a little bit confused. I think officers are allowed, as a matter of course, to ask about travel plan questions.
No matter what. I mean, this is important, counsel, and you've now taken two different positions while you've been standing there.
Well, and
So
again,
which is it? Are
as
they
a matter-
always allowed to ask travel plans, or does it depend on the circumstances?
I believe they're always allowed to ask about travel plan questions. They're permitted to do so by law. Whether or not the officer actually does so, that I think is a different question. And I think the type of travel plan questions vary depending on the circumstances. But I think as a matter of course that they're allowed to ask about travel plan questions.
So what
Sorry
difference
to
does it
jump
make?
in.
No, I'm just trying to clarify, it doesn't make any difference. That's kind of what I was getting to. So time of day really doesn't make any difference under your primary theories. They can always ask about it.
They can always ask, but again, I believe that the question asked, in these circumstances, what would have justified asking the travel plan questions?
And extending the stop and you, okay.
So, and again, I apologize if it sounds as if I'm going a bit back and forth. It's just that, again, based on, and both the cases I would ask that this court to review is that this court's own ruling in Morlock cited United States versus Rivera. In Rivera, there was a lot of questionings prior to the officer calling into dispatch that ran a whole gambit of questions about his criminal history, travel plans, and things of that
Was
nature.
that before Rodriguez?
That was, yes.
Do we make anything of the fact that this case and the third case on today's docket has the same officer stopping a out-of-state car for the same offense of following too closely? And in that case, it was 6 minutes, 11 seconds until they phoned in to dispatch. In other words, we have a pattern here going on in your area. Does that make any difference? I know we allow pretextual stops, but does that impact anything here if this is like this is the way we do business in Geary County?
No, because I believe there's no requirement but by case law that says an officer, upon immediately getting somebody's driver's license, has to immediately call it in. And I believe that the case law cited by the state shows that it's a common practice to just ask travel plan questions while the officer's getting driver's license, proof of insurance, and things of that nature. And then reviewing those while either that in the car, talking to the driver, or otherwise. Because even the taking case that's on today's docket, the officer didn't call in to dispatch, and he was asking travel plan questions. So
And there it was snow on the license plate instead of following.
right,
was it?
right.
So are you saying, I'm a little unclear about Rodriguez. You know, it's specifically said the critical question's not whether the dog sniff, the delay, was before or after the issuance of the ticket. And I heard you say that Rodriguez only applies for post ticket issuance, and the case says explicitly that's not the critical question.
Because in Rodriguez, they were very clear in making a distinction that a drug canine is not part of a traffic stop. So whether it falls within that time period, that it doesn't matter. The court drew a very bright line distinction about deploying a drug canine was investigative in nature.
Any more questions? Thank you, counsel.
Thank you.
You reserve 3 minutes for rebuttal.
Thank you, Your Honor.
Counsel, before you begin, are you familiar with these cases that was cited by opposing counsel from the 10th Circuit?
I'm familiar with one of them, Your Honor, that being the Pettit case. I'm not familiar with the other two the counsel cited.
Are you able to respond to the Pettit case in your rebuttal, or not?
I'd be happy to, Your Honor.
All right.
As I read the Pettit case, it was a travel plan questioning in 2 parts. The facts of that case were the officer requested, I believe, insurance information, which it took a little bit of a while for the driver to find. While he was looking for that insurance information, the officer was asking travel plan questions, which were not extending the stop because he is waiting on the individual to give him information he needs to process a traffic citation. Once he got that information, he went back to his vehicle, he completed the citation. I don't remember whether he gave it back to the driver or not, but the citation at that point was complete. He then began to ask more travel plan questions. He continued detaining him, did not return his license, I do remember that, and kept him detained while he continued asking travel plan questions. And the question that the Pettit court answered was, and the issue before the Pettit court was, did the officer have reasonable suspicion before he extended this stop to continue asking travel plan questions? And ultimately the Pettit court concluded that the officer did, that the first set of questioning, which did not extend the stop, gave the officer reasonable suspicion to further extend it at the conclusion of the traffic citation. But that was the central issue in the Pettit case. The court says that is the central issue. Whether or not there is reasonable suspicion at the time that the traffic citation was complete and the driver was further detained for additional travel plan questioning. So I believe that Pettit case is completely consistent with Rodriguez and completely consistent with the reading of Rodriguez that the district court judge took in this particular case.
Thank you.
I would also like to clear up one factual issue, Your Honor. This stop did not occur at night. It occurred at 2:28 p.m. A review of the video clearly shows that it happened during daylight hours. I don't know that that's a critical fact in terms of making a decision on this case, but I did want to clear that up. And unless the court has further questions, I'm prepared to waive the remainder of my time.
Any more questions? Thank you, counsel.
Thank you, Your Honor.
Appreciate the arguments by both counsel this morning, and the court will take this matter under advisement.